our Law Review Symposium, Corporations and Their Communities. Each year, and in what we hope will become an annual event, the Law Review hosts a symposium on a topic that we think deserves more consideration and thought than one Law Review article can cover. Corporations and communities will focus on the legal relationships that develop between corporations and the communities within which they operate. We hope that the topic will be timely and appropriate for everyone involved, and we feel that we've, assembled a group of very distinguished scholars and lecturers who will talk about these issues. To, demonstrate the timeliness of the article, yesterday's New York Times featured an article on Walmart's social manifesto, a response to concerns of communities and individuals. And last week's Economist published a feature on the future of corporate social responsibility. And we hope you'll enjoy the next 2 days. And without any further delay, I'll turn the symposium over to Dean for Academic Affairs, Jonathan Eynden, who's also advisor of the Law Review. Thank you.
Okay, thanks, Adam, and welcome. Ordinarily, the person who, as a matter of protocol, should be standing up here is Dean Gary Simpson. But as some of you know, the dean has been making an extraordinary recovery from a fractured hip, and he has actually taught all of his classes so far this semester and presided at 2 faculty meetings, which I think is beyond the call of duty even for people who don't have medical problems. But on behalf of the school, I want to welcome you all. This should be a terrific program, and as Adam says, a timely one, one that raises some important questions, both of theory, but also of practice. Particularly in this part of the world, issues relating to corporations and their communities have a real resonance. We have a number of major auto plants, for example, where concerns about survival or downsizing or relocation are on the front burner. We've had issues in the city of Cleveland about whether and under what circumstances Walmart would be allowed to open a superstore. We have issues in the city of Cleveland about the use of eminent domain for economic development, and I think we're going to be hearing about that. And a couple of years ago, the Supreme Court of the United States had a case involving tax incentives that came out of the city of Toledo, a case that deals with some really important issues that the court did not resolve because it determined that the challengers in that case didn't have standing. But we do have a very, very good and eclectic group of scholars and practitioners. I'm looking forward to the program. I hope you will. And with that, let me welcome you, as I said, on behalf of the school, and turn to our first panel on stakeholder theory, which will be moderated by my colleague Richard Gordon. And Richard will introduce the people up on the bench here. Take care. Welcome.
Thank you very much. I'm going to be moderating from over here, so I hope all of you will be nice and moderate. First, I guess, Kent, you're going to speak first. Kent Greenfield, who you taught in Hawaii, is that right?
I did.
So I think the contrast between the weather in Hawaii and here should be nice to begin the whole discussion. Also, Kent wrote a book called The Failure of Corporate Law, which I think is a good introduction to your point of view you'll be expressing this morning. But you at least did attend the University of Chicago Law School, so you're familiar with the winter up here in Great Lakes area. And I think after Kent, then we'll give his paper, and then Tim Glynn is going to speak. And Tim, whose sort of area, I guess, of specialty really is corporate and employment law and the intersection between the two, which of course is very relevant to stakeholder theory. And a graduate of the University of Minnesota Law School, you're also familiar with being out in the prairie, I suppose, is even more important to dealing with the weather here. And then, of course, everyone knows George Dent, who has more degrees from Columbia than I think just about anybody else in the world, and who is my colleague in teaching BA, and I know quite well. And even though he did root for the Indians while I was rooting for the Red Sox the last time we went to a baseball game, we're looking forward to his comments after our two speakers present their papers. So thanks. Kent, you might as well just...
Thank you all for coming and giving up part of your Friday. Thank you, Dean Eynden, for introducing the day, and thank you, Richard, for introducing the panel. I might add one additional reference point to Dean Eyndon's remarks. I often teach the local 1330 case in my corporate law class, which pertained to the U.S. Steel closing their plants in Youngstown during the early 70s. And so I often think of this area as I teach corporate law, but this is my first time to ever have given a paper here, so it's a particular delight for me to be here today. I am going to illustrate some of my remarks today with some slides, and if for some reason you want a copy of the slides, they're reproduced over here. We're having some difficulty with the perfection of the reproduction, but at least we'll give you an idea of them, and some of them will also be in the paper that I eventually publish with this paper. So let me start by saying that I am a strong believer that corporations are meant to create wealth, and that is their comparative advantage. Where I differ from most mainstream theorists of corporate law is that I believe the definition of wealth is too narrowly constrained in the traditional.
You're definitely not Richard Gordon.
Okay. In the traditional view of corporate law and corporations. Corporations are immensely powerful, and if we were able to harness their power for good, we would really have a tiger by the tail. Of the 150 largest economic entities in the world, 150 largest or most powerful economic entities in the world, 91 are corporations. So if we were able to cabin their power when they do bad things and bolster their power when they do the good things, we would really have something. So I believe that corporate law and corporate governance is not only part of the problem that we face in America and indeed the world today, but also might be part of the solution. So that's the thesis of my talk and my paper. And let me now give you some more details. Economic policy can be driven by a number of different policy norms and policy beliefs. One might be that of FDR, who said that the test of our progress is not whether we add more to the abundance to those who have much. It is whether we provide enough to those who have too little. Now, another way to think about economic policy is that of Ronald Reagan, who said, "What I want to see above all is that this remains a country where someone can always get rich." Two vastly different notions of what government is about and what economics is about. And we certainly have chosen more of the latter, more of the Ronald Reagan view, over the last generation or so. And there have been a couple of results of that view, of following that view, that are particularly of interest to me. Stagnant wages for working families and growing income and wealth inequality. Let me illustrate this a bit by showing this graph. It is, and with this lighting, it's very difficult to see. I don't know if there's a way to reduce the lighting right at the screen, but we'll if you trust me on this. This is a graph that shows average income growth by household from the early 80s, late 70s to the present. And if you can see the bottom very dark line, that is the lowest 20, the poorest 20% of Americans. And the very vague gray line, that's the top 1% of Americans. So since 1979, the poorest fifth of Americans have seen their income remain remarkably stagnant, while the top 1% of earners has soared. Now, another way to illustrate this is growth in real household income, and we can break it down even more. The highest quintile, you can see sort of about a two-thirds of the way over the slide, has seen their income go up in the last 25 years or so by almost 50%. But the richest among us, the top 1%, have seen their income more than double in that same period. So, in fact, the most recent data that appeared in the New York Times last year is that the richest 10% of Americans, when I say richest 10%, I'm not talking about people who earn $1 million or so, but people who will graduate from this law school. If you make more than $100,000 a year, you're in the top 10% of Americans. The top 10% of Americans bring home half of all personal income in the United States. Okay? To make an even more profound illustration, the richest 300,000 Americans make as much as the poorest 150 million Americans. So half the population makes about the same as the richest 300,000. So this growth of inequality in income is a result of not only of exploding incomes at the top, but stagnant wages at the bottom. Working class families essentially make about the same in real terms that their parents made in the Nixon administration in the early 70s. Now, this inequality is even worse if we look at wealth as opposed to income. Now, this slide is probably overwhelming the danger of doing PowerPoint. You can study it in more detail later. But the first column is essentially income. So the bottom, if you look at the bottom 90%, the lowest row on the left, in terms of household income, the bottom 90% get about 60% of the income. But if you move your eyes all the way to the right column, in terms of net financial assets, they only own about less than 20% of all the wealth, as opposed to income. So the top 1%, in contrast, get about 17% of the national income, personal income, which is extraordinary in its own right. The top 1% getting 17% of its share, so to speak. But in terms of net financial assets, over 40% of the wealth. So this inequality in income sort of accelerates and is even greater with regard to wealth. And this has an accelerating power overall. And then again, if you can't read it, in 1962, the richest 1% in terms of wealth had about 125 times that of the median American. Now it's up to 190 times that of the median American family. So why is this important with regard to corporate law? Well, before I ask that question, let me give you one more illustration. This shows sort of a historical trend with regard to the concentration of income by the top 1/100th of 1%. In the last year, the New York Times made a big splash by announcing that the top 1/100th of 1% of Americans had a greater share of national income than they had at any time since 1929. So if one thinks that that history goes in cycles, one might be worried about what that says. So why does this matter to someone talking about corporate law? Now, I think that what I want to get across is that I do think that part of the reason we see these trends is because of how we regulate and govern large businesses. Now, at one level, at a superficial sort of first cut, it makes some sense, or it would be surprising if it didn't have some relation, right? the largest source of national income is corporate wealth and corporate activity. The corporate sector produces about 60% of the national income in any given year. So if we see that that's the largest source of national income, and at the same time we see that income and wealth is growing in disparity and inequality, something might be wrong with regard to how we regulate businesses and corporations. And I do think that that is the case. And I think that corporate law and corporate governance law is part of the problem for a few reasons. First, I believe that there is a pathology with regard to corporations that makes them externality machines. Of course, externalities are simply an economic term for those costs, sometimes benefits, that are spun off, that are not internalized by the decision maker. So we have external costs in our behavior as individuals, but we also have a conscience. And we are subject to certain reputational norms that corporations are not. And so the corporate form protects corporations from internalizing their external costs. And because they have no conscience, and because we create them in such a way to fixate on financial wealth. So external costs, whether it be pollution or unemployment, or discrimination against people who are of color or who are sexual minorities, all those externalities only matter to a corporation if they are translatable to money and in financial terms. So externalities is one reason why corporations are part of the problem. Another part of the problem is shareholder primacy and short-termism that is created by shareholder primacy. Now, we can bicker about how strong the shareholder primacy norm is, but I believe that there is no doubt that because of a mix of law, norms, and market pressures, that shareholder primacy is indeed the norm in corporate governance in the United States, and all those factors work together to enforce a fixation on stock price in the short term. Now, a number of these things that work together in this respect sort of come together, and they don't really have their traction or have their footing in law, although law gives them some power. For example, the fact that the stock market in the United States is owned 60% by institutional owners, hedge funds, insurance companies, pension funds, and the like, all of which have their own inexorable push and demand to show profit, and to show profit in the short term. Increasingly, the stock market is very short-term oriented. 2006, the average stock turnover in the stock markets in the United States is 118% on an annual basis. What does that mean, 118%? It means that on average, each share of stock is bought and sold at least once per year. For Fortune 500 companies, it's even more rapidly sold. There's more rapid turnover. So what does that mean? It means that for the average shareholder, long-term gains don't mean anything, because if it's more than a year out, if a gain that's more than a year out, it does not mean anything to them, because they're going to sell the share of stock before that time. So if anything that we want corporations to take into account that will inure to the benefit of shareholders or to the company more than a year away, then it won't be incorporated into the short-term decision-making of most share owners. And in fact, this plays into managerial decision-making. In a recent survey, 80% of corporate managers said that they would, in deciding between two choices, one of which would bring about long-term gain for the corporation but have short-term costs, and then the other impose long-term costs on the corporation but for short-term gain in order to make short-term quarter-to-quarter targets for Wall Street. 80% of managers said that they would impose long-term costs in order to meet their short-term obligations. So, to make a concrete example here, one of the famous episodes in New England corporate law and corporate governance, or corporate management, is the experience of Aaron Fierstein, who was the CEO of Malden Mills. And you may vaguely remember this, probably about 10 years ago now. His factory burned down on Christmas Eve, or the week before Christmas. And he said the day after that they would rebuild the factory, and that he would still pay bonuses for Christmas, and he would pay all of his workers in this apparel factory there through the Christmas holiday. That company was privately held, was a privately held company, so he could decide those things. If it had been a publicly held company, I strongly doubt that would have been possible for him to do. Because doing the right thing often costs money, at least in the short term, and sometimes even in the long term. And that's impossible for a company that has to make sure that the next quarter targets are satisfied. So that's the second thing why I believe that corporate law is part of the problem. Externalities, shareholder primacy. Thirdly, these things work together to help create the very income and wealth inequality that we talked about before. Now, why is that? A shareholder primacy norm is a norm that moves wealth to the rich among us. Why is that? Well, here's another chart that might be overwhelming to you if you don't have a chance to study it. But let's look at on the far left of it. This is the share of capital income. What percentage of all the capital income flows to who does it flow to? 57. The white bar graph is 2003. The black is 1979. So this shows the change over the last 25 years or so in the share of capital income. The richest 1% of Americans now receive almost 60% of all capital income in the United States. So a rule that says that shareholders win is a rule that says the very richest among us wins. The bottom 40% of Americans receive about 2% of the capital income, and that's even counting pensions and the like. The bottom 80% altogether receive less than 15% of all capital income. And something that you can't show on this graph is that, so this is the share of capital income. It goes to the richest among us. In terms of the national pie, the national income pie, a growing share of that pie goes to capital income as opposed to labor. And that's not unexpected, since we have, as part of our law, almost a requirement to transfer wealth from labor to capital. And so the slice of the pie that goes to capital is growing, and a larger piece of that pie is being eaten by those who are already engorged themselves before. And in fact, because of this shift from labor to capital, this is another reason why wages are depressed and stagnant. In fact, one study says that wages are 5% lower today than they would have been if the share of capital income had just stayed flat since 1979. Another reason why we see income inequality as a result of corporate law is because of the deference shown to management in their own compensation. This is the chart. In 1965, the ratio of CEO pay to worker pay was about 25-1. And we all see these comparisons all the time. And I'm using a very conservative one here. By a conservative account now, or at least in 2005, the ratio was about 260-1. So what that means is that a typical CEO goes to work on January 2nd, and by the end of the day, that CEO has made more than the typical worker will make the entire year. The other reason why corporate law has some impact on this is that there's this transfer from labor to capital, even if it's not true in the short term, it's certainly, even if it's not true in the long term, it's certainly assumed to be true in the short term. There's something on Wall Street called the 7% rule. And what it says is that, well, the best way to bolster your stock price in the short term is to announce layoffs or wage cuts. Because Wall Street loves it when you cut employment, because it shows that you're tough on cutting costs, and it shows that you're dedicated to a focus on profit rather than long-term human resource development. So the 7% rule is that there is a rule of thumb in Wall Street that says if you announce a big wage cut or layoff, you get a 7% bump in your stock price. And as I say will say in my paper, this actually proved out to be the case in a lot of instances. And so what happens, even though in the long term it might be a wash, in the short term it's often quite true. And even if it's not true all the time, it's true often enough that CEOs see it as a decision-making mechanism, or see it as a rule that they want to follow. And it's such a rule that even political commentators and cartoonists use it in their own work. So what to say in? Did everybody read the cartoon? Okay. All right. So corporations are not all bad, obviously. They could be part of the solution. And one of the things that I want to get across in my last couple of minutes here is that I think if we started seeing corporate law and corporate governance law as part of the possible solution, we could do a lot. Now, one way to do that, we have to start by changing some of our assumptions about the nature of the corporate form. I don't believe it's correct to say, or most accurate to say, that shareholders are the owners of the corporation. Sure, they contribute inputs, but so do employees and communities and creditors and suppliers. And I'll use a chart or a diagram that was developed by my friend Alan White at Corporation 2020. And again, you can't really see this on the screen. But the notion is that the corporation really is a web of contracts, a web of relationships. And everybody contributes to the corporation, whether it be employees or shareholders or the environment, customers, communities, governments, and the like. And not a single contributor to the firm is doing so out of altruism. Every single contributor to the firm is doing so because they want something back. They're all making what they believe is a decision that will maximize their return, whether through salaries, shareholder return, interest rate return for creditors, products for customers, or tax receipts for governments and the like. So one might say that once we recognize the corporation as a collective enterprise, that we need to take into account that all of these stakeholders, that all of these constituencies, that all of these contributors should be taken account of and care of, and that absent regulation to protect all of these stakeholders, that we risk their exposure to exploitative behavior. Now, one might say that, well, we do have a whole host of regulations to protect all of these stakeholders. But one thing that I would like to point out, and again, this might be difficult to see given the nature of the screen, but there are, if you think about this as a matter of regulatory theory, and think about the stakeholders on the left, you've got shareholders, and employees, and communities, and customers, and creditors, and then think about the ways that we seek to protect them. Assuming, first of all, that regulatory theory would suggest that the optimal level of regulation to protect these stakeholders is not zero. So we all protect them somehow. And we focus on a number of different ways to protect them. Regulatory theory might focus on results. We need to protect them from certain outcomes. We may want to think that regulatory efforts are to focus on actions or processes within the firm. We want to force the company to do something in a certain way. Think about anti-discrimination law. Or we might think that the regulatory focus might be on structure. We should affect and change the corporate structure to make sure that these constituencies or stakeholders are taken into, are protected. I won't go through each of these ideas, but shareholders are protected in a number of different ways, right? That we have regulatory efforts focused on results. We have regulatory efforts focused on processes and actions, anti-fraud law, for example. We also have protections related to the structure of the firm. Shareholders vote for directors. Shareholders vote for major organic changes. Shareholders may sue derivatively. Employees also have regulatory efforts focused on them that focuses on results, minimum wage, for example, and on actions and processes, tort law, anti-discrimination law, but have no structural protections within the firm. The community and the environment also have regulatory protections focused on results, environmental statutes, for example, or on processes, permitting, zoning, but still don't have any protection under the structure of the firm. Customers also have regulatory protections according to focused on results and focused on processes, and you see where I'm going. Creditors also have protections through results and processes, but no stakeholder other than shareholders have protections through the very structure, the democratic structure of the firm. And regulatory theory might suggest that these empty rectangles on the right mean that there's an unrealized resource within corporate governance to help those stakeholders be protected in certain ways. Now, why might we want to fill up those boxes? One reason is that filling up those boxes might be more efficient as a regulatory mechanism. Because the existing regulatory mechanism, think about protecting employees, either focus on post hoc settling up, welfare law or the like, Social Security, or on focuses on the lowest tier of employees, minimum wage. But if we incorporated, no pun intended, maybe pun intended, the interests of employees into the fabric of the firm, they would become much more of a guiding force in the very decision making and might actually be more efficient in reaching the goal of dampening income and wealth inequality and bolstering the wages for working people. Think about the example I often use. It's maybe more efficient. There are two ways to clean a river. One is to clean it up after it's dirty. The other is to make sure that the pipes releasing the effluent don't release the effluent. It's much more efficient to catch the damage before it occurs. So similarly with employees and employee wealth, it might be more efficient to allocate corporate resources at the very beginning of the pipeline rather than at the end. Now, one can gain insight from areas of the world where the interests of employees are already internalized within the firm. And I'm talking here about the co-determination that exists in Europe. 18 of the 25 European Union countries have co-determined boards, meaning that some percentage of their board of directors is elected by employees. And it hasn't driven Europe into the economic abyss. And in fact, in European countries with strong co-determination norms and traditions, they have lower inequality, higher labor productivity, lower unemployment, fewer days lost to strike. German workers, in Germany, where the board of directors is half employees, half shareholder representatives, German workers work fewer hours and make more money than American workers do. And it's not surprising, right? So there are different ways to do this, and Tim Glynn may talk more about this, but one way to illustrate this, as we look for possibilities, if we think about the current board makeup, it really is representatives of the shareholders only. And one can craft different ways to include and internalize the interest of employees. But one possible board makeup is to simply put employee representatives on the board of directors. It's fairly easy to do. You simply, in the articles of incorporation, add a different class of stock, give every employee one share, and have them vote it each year to name their representatives. Or, even more provocatively, you could have a board that is a true stakeholder board with shareholder representatives, employee representatives, and community representatives on the board too. Now, the details of how we do this we can work out, but I don't think we should be shy. This is my favorite quote by a Supreme Court justice. If we would guide by the light of reason, we must let our minds be bold. And I do think that with some bold thinking here, we could do quite a bit. Thank you very much.
Can I use your slides?
And now we'll hear from Tim, and George can comment after you've completed.
Great, thank you. And thank you very much for having me. I wanted to thank the members of Law Review for putting this together, the faculty administration at Case Western Reserve University School of Law, not only because it's a terrific opportunity for us to get together and have a good time, but also because I think these are really fundamental questions that we have to think about in a world with a whole host of challenges. And whether you view this problem through a local lens, a global lens, or a lens where you look at the interaction of the two, the corporation has to be in the center of that discussion for many of the reasons that Kent described. These are not only enormously powerful institutions, they are also institutions with enormous potential that I believe we can harness in different ways to deal with the kinds of challenges we face in the next couple of decades. Climate change, the pressures of globalization, healthcare issues within the United States, even pressures on our democracy itself. So my idea here is to harness the potential of the corporation rather than to argue that somehow we ought to remove it or ignore it in the discussion. Couple of points, and I'll get right to my sort of two-step analysis of how do we get to a stakeholder conception in this country. Just to reiterate a couple of points that Kent mentioned. One, I think that just about everybody agrees that the purpose of the corporate form is to enhance social welfare. In fact, a contrary argument would be very strange since corporations are creatures of law. They do not occur naturally. They are a product of law. Why does law recognize them? To enhance social welfare. Then subsidiary points to that are, one, I don't think there is, at least in this context, when we're talking about corporate law and corporate law norms, there's a dispute that corporations have the enormous potential to create wealth, or that reasonable returns for those who invest capital are useful in the creation of that wealth. So I don't think those things are in dispute here. The debate focuses on whether these larger social ends in general are served by the current structure of corporate law, which, whether it actually achieves this end or not, is focused in the American context on shareholder wealth maximization alone, to the exclusion of other constituencies. The dominant modern approach to the subject of corporate law, at least in the American context, is a very narrow one. For the students, but I guess I would include the lawyers and the professors in the room. Recall your business associations or corporate law class. What did you focus on, or at least what did you focus on the vast majority of the time? Well, it wasn't the interests of other constituencies. Maybe you spent a class or two talking about the Ford case, talking about Milton Friedman's view, talking about corporate social responsibility, but by and large, you were talking about the relationships between management, directors and officers, or managers in LLCs or other types of entities, and shareholders or members. You were talking about those relationships, not other relationships, in your corporate law course. Corporate law in the American context has focused only on the relationship between those two stakeholders. So regardless of the lens, whether we think of corporate law through a contract lens, through a property lens, or an agency lens, these are the dominant lenses that we use in the American context, corporate law for for-profit entities is largely treated as a form of private law governing two sets of stakeholders and two sets of stakeholders alone. All right, completely excluded from the doctrine then, even though they are not excluded from the theoretical discussion or the public policy debate, are other constituencies or stakeholders in the firm: workers, customers, creditors, and the local, state, and national communities within which corporations operate. Protection of these interests from corporate decision-making is left to forces outside of corporate law in the American context, either to market forces or to external, as Kent talked about, external legal regimes, other approaches, other mechanisms for regulation. Stakeholder theory has been stated in a variety of ways, but the unifying idea is that the corporation's responsibility extends to constituencies beyond simply stockholders. But to be clear, stakeholder theorists do not agree on who these constituencies are or how corporate law ought to be structured or restructured to further these interests. For example, there are director primacy theorists, those who believe that directors and firm managers ought to be very free under the business judgment presumption and other doctrines to chart the course of the firm relatively independent of the shareholders. Some director primacy theorists think that the reason they ought to be free to do that is because if they are free to do that, they will choose a long-term type of approach to wealth production that will benefit all constituencies. So there are some stakeholder theorists who take that position. There are what I would call shareholder primacy theorists. My phone is ringing. I tell my students in class, maybe it was a signal to me to slow down a little bit. I tell my students in class to turn off their phones inevitably the second or third class because I use my phone as my watch. At least I did this year because I broke my watch. The phone goes off in the middle of class. And anyways, I digress. There are others who are what I would call shareholder primacy theorists, and I'm using the term here a little bit differently than Kent used it. He used it to reflect the shareholder wealth maximization norm. I'm using it in a more narrow sense to talk about those theorists who believe that greater focus in corporate law on the protection of shareholder interests and access to governance by shareholders will produce better outcomes. There are shareholder primacy theorists who believe that taking that approach will not just benefit shareholders, but will also benefit other firm constituencies. Then there are other stakeholder theorists, and I think I would put Kent in this group, and I've fallen into this category, who were skeptical that either of those approaches, because they don't consider other constituencies more explicitly, will in fact result in the kind of protection of other stakeholders or the facilitation of other interests that those groups suggest. So those are the categories of stakeholder theory and sort of where we fit within that. Now, let me turn then to the heart of my presentation. Kent has really laid out, I think, the broader theory here. What I would like to do is focus on what he talked about at the end, in a slightly different, but taking a slightly different direction, which is how do we get there from here? How might we actually institute a legal regime that would take a broader approach to the purposes of the firm and to the protection of other stakeholders, integrating explicitly other stakeholder interests into our corporate governance structures and norms. I would suggest to you that given the current structure of American entity law, we are really 2 steps removed from a broader stakeholder conception. First, if we are serious about rethinking the role of corporate law and decision-making in our society, we need to consider where and how corporate law is produced. Put another way, at the most fundamental level, if local, state, and national communities are to have a stake in the corporations within them, they must have a voice in the creation and enforcement of corporate law. Secondly, once we recognize that corporate legal norms ought to be made and enforced, at least to a greater extent, by the community's firm activities substantially affect, we then consider the mechanisms by which these interests, the interests of various stakeholder groups, might be represented or protected in corporate governance. So let me talk about the first step. And this is actually the step which my title refers to, so I have to take a moment to talk about the title. So we have at Seton Hall, like Case Western, we have a website where we post all the various things that people are doing, including the presentations people are making that week. We have a faculty member who is responsible for this. Earlier this week, I sent him the title of my talk for today. Yesterday, before I got on the plane, I stopped by his office, and he looked at me and he shook his head, and he said to me, I almost didn't post that on the website. He said, and he goes, Nullibiety. No, I can't even pronounce it now. Nullibiety. Nullibiety. It's not even in the Oxford English Dictionary. How could you possibly think that you're going to convince anybody if you use words like that? I was a little taken back and indicated to him, first of all, that I don't think the Oxford English Dictionary has a monopoly on the language, 1. And 2, I said to him, he's a big New York Times crossword puzzle person. I said to him, when Nullibiety shows up in the New York Times crossword puzzle, you owe me a drink. So, and I left it at that. Interestingly, how I got to the title, this Nullibiety and Ubiety notion, is I was talking to one of my colleagues who is a property scholar, and I was telling him a little bit about this presentation and how it fits into sort of some of the other, sort of my larger scholarly agenda. And he's like, "Oh, you're talking about Ubiety," which I'll tell you how I'm using that term in a minute. And I said, "Well, tell me more." And he told me how he thinks of this concept of Ubiety, and for the property folks in the room, you may be familiar with this. From Ubiety, then I got to the idea of Nullibiety. So that is an explanation for the title. Let me explain where I am going with this. When oftentimes as a society, when we think about the challenge that local, state, and our national communities face in seeking to influence and regulate corporate behavior, particularly in a globalized world, we focus on the another concept, the ubiquitous character of corporations. So, ubiquity. What do I mean by that? That is, the business firm potentially exists beyond the confines of any particular physical space or community. Instead, it potentially exists everywhere. It can attract capital, develop supply chains, sell products or services, and perform its operations anywhere or everywhere. This provides firms with leverage when they deal with particular communities within which they operate. Firms can demand concessions from government officials, employees, or others in exchange for not leaving, for maintaining the size of their local presence, or otherwise. And this produces competition between jurisdictions to attract or retain corporate activity. Although obviously this interjurisdictional competition notion, its ultimate efficiency is in dispute, this kind of interjurisdictional competition creates a race to the regulatory bottom and a willingness of communities, workers, and others to accept terms that they would otherwise not accept. Appropriately then, the ubiquity of the corporation frames some of the discussion about the relationship between corporations and communities, and I think it's going to frame some of the discussion here this weekend at the symposium, and that's appropriate. But there is another challenge communities face in dealing with corporations. When considering the legal norms that frame its governance, the corporation may exist in a state of nullibiety, that is, in the condition of being no place, or at least no place that is relevant. Corporate law in this country is produced in a peculiar way. Except for the federal securities regime and the SRO rules that govern our public markets, corporate law is a creature of state law. At the state level, and by the way, that regulation of public markets extends really only to disclosure and anti-fraud provisions. There's a few other things that sort of regulate substance, but in general, our federal regime has avoided regulating the substance of corporate governance. At the state level, there is one dominant producer of internal corporate legal norms, at least for larger enterprises. 60% of U.S. publicly traded firms are incorporated in Delaware, the nation's second smallest state, and hundreds of thousands of other privately held entities are chartered there as well. This is true even though a very small percentage of Delaware corporations are actually headquartered in the state or have major operations there. All right, Delaware does regulate the governance of Delaware chartered firms, including by establishing the basic rights of shareholders and the fiduciary duties of corporate managers, although its approach favors private ordering and therefore is highly deferential to management. This is something that many shareholder primacy advocates have criticized, and because most other states have followed Delaware's lead on corporate legal norms, its deferential approach is at the center of corporate law's race to the top, race to the bottom debate on which much ink has been spilled. Delaware's legal decision makers are captured, primarily by managers, but at most by managers and shareholders. Delaware receives about 25% of its annual revenue from its chartering business, which is an enormous percentage of state revenue, as compared to any other jurisdiction. And it supports a substantial corporate litigation industry, so there are indirect benefits as well. And because the vast majority of firms chartered in Delaware do not operate there, and hence most of the costs of its corporate governance regime are externalized to other jurisdictions, Delaware's legal decision makers have little incentive to consider other interests or stakeholders in promulgating corporate law. Thus, managers primarily and shareholders secondarily, along with the Delaware Corporate Bar, are the only interest groups that have any potential influence on the state's corporate legal norms. The only other existing constraint on Delaware, at least at this time, is the looming threat that in times of popular discontent, the federal government might take away Delaware's chartering franchise and that enormous amount of revenue that the state receives. Thus, no matter how important the impact of corporate decision-making, something that Kent focused on, I wish I could steal his slides, that sort of that last category, no matter how important that is for any stakeholder group or all stakeholder groups, under the existing regime, the law of corporate governance is beyond the reach of all except managers and, to a far lesser extent, shareholders, as long as the firm has been chartered in Delaware. This is what Professor Greenfield has described in his book as the undemocratic nature of corporate law. Other stakeholders have no political influence over it whatsoever. This is the ultimate triumph of private ordering over public mandates. Though through the chartering decision, corporate promoters can opt out of being regulated internally by any state in which the firm has substantial operations or where other stakeholders, including shareholders, by the way, have far greater political power. You can simply opt out without moving physical operations. This is why I've characterized the state of corporate law in this country as one of Nullibiety. It is, in a very real sense, aterritorial. Corporate legal norms created and enforced by Delaware are unmoored to the communities in which the corporate decision-making will have its greatest impact, or at least a far greater impact than it will have on Delaware. Now, the nature and dominance of Delaware corporate law has enormous ripple effects. Let me just take a moment to talk about those. Other states, responding to the ability of home state firms to opt out by chartering elsewhere, typically have followed Delaware's lead into permissiveness. This is due in part to a response to the competition and interest groups not wanting to lose in-state charters, but it is also due to some extent to inattention on the part of other constituencies. Yet Delaware law has an impact well beyond allocating the rights between management and shareholders. Again, because the firm is governed by managers selected and acting under this legal regime, management has no affirmative obligation to consider the welfare of other stakeholders except to the extent dictated by market forces and external legal mandates. Critically, viewing themselves as seeking to maximize the firm's surplus to split between themselves and the shareholders, management is likely to comply with these external legal mandates only to the extent that the costs of noncompliance exceed the costs of compliance. Moreover, absent external legal constraints, there is no legal doctrine that prevents management from increasing the surplus by externalizing costs onto other stakeholders. Kent talked when he was talking about the 7% notion, and in times of crisis, what Wall Street wants to see is layoffs. You externalize the costs of seeking to increase shareholder returns by externalizing those costs onto workers. Indeed, under the Caremark and Stone line of cases, directors have no meaningful duty to establish monitoring systems that might otherwise root out and correct even illegal conduct, not even a duty that's enforceable by the shareholders. In addition, the substance and effectiveness of external legal mandates are directly affected by Delaware law in other ways. So if we think of the corporation as being limited in what it can do with these other to these other stakeholders because of external legal mandates, what I'm now suggesting is that Delaware law has a critical effect on these external legal mandates as well. For example, because Delaware law addresses internal corporate arrangements, and because internal corporate arrangements are relevant to veil-piercing doctrine, many states apply the chartering state's veil-piercing doctrine, which, for a host of reasons, may facilitate further externalization of risks created by corporate activities onto other stakeholders, third parties, or the public as a whole. Federal law, in a number of regulatory contexts, borrows from underlying state corporate legal norms. Again, a spillover effect. In addition, as I argue in a forthcoming paper, firm managers may begin with greater frequency to utilize the state of incorporation as a choice of law hook to ensure that their contractual relationships with employees and others are governed by their preferred law. Finally, all of this creates a feedback loop that puts enormous pressure on our democratic institutions. In service of only the interests of shareholders and themselves, and free to decide, under the business judgment presumption, how this end is achieved, management is free to use the firm's considerable wealth to influence the substance and enforcement of the very external legal mandates that might otherwise protect other stakeholders. So there is a feedback loop then which puts pressure on our democratic and regulatory institutions. All right, real quickly, there are two other circumstances that allow Delaware law. There are two circumstances that allow Delaware law to have this kind of impact. One, as I mentioned before, is that the federal government could, but has not yet chosen to federalize this area, and that would be our national community governing. But it would at least be a more relevant community, in my view, because there would be greater political influence by other stakeholder groups. Even though there was some talk of federalization after Sarbanes-Oxley, and even though shareholder primacy theorists, many of them favor that as well, that did not occur while Sarbanes-Oxley was being discussed. The sort of post-Enron concerns did not lead to federalization in that way. The second legal or structural component that allows this to occur is what we call the internal affairs doctrine, a horizontal choice of law rule that provides that the law of the state of incorporation governs the relationship between the firm, its shareholders, and firm management. Although this doctrine sounds narrow, it certainly would be implicated in any kind of reform along the lines that Kent was talking about. This horizontal choice of law rule is largely adhered to by other states. Now, it's sort of an interesting puzzle why that is, although it's clear that history, interest group dynamics, and in Professor Greenfield's words, a lack of imagination have played a role. But here's the critical point then with regard to those circumstances. Other states do not have to adhere to the internal affairs doctrine. In other words, other states do not have to apply the corporate law of the chartering state. There is no constitutional doctrine Delaware's arguments to the contrary, there is no constitutional doctrine that mandates the internal affairs doctrine be applied by other states. So, given all of this, the first step in seeking a change in the structure of American corporate law that would incorporate a broader stakeholder perspective would be then to change how we make law, where and how we make corporate law. And my suggestion is that the states in which corporations actually operate, or in some circumstances the federal government, ought to be in the business of making corporate law, rather than allowing managers to outsource corporate law to Delaware, where no one else, maybe to some extent shareholders, but no one else has any political influence whatsoever. That's the first step. Now, what I suggest then is that that step takes us from Nullibiety to Ubiety in corporate law. So we need to move from Nullibiety to Ubiety. Ubiety is the condition of being located in a particular place or a relevant place, a sense of awareness. Not awareness, but awareness. We need to move from Nullibiety to Ubiety. At minimum, this would make those who govern corporations more politically accountable to the communities within which they operate. What it would also do then is facilitate local experimentation in forms and structures that incorporate a broader perspective and potentially other constituencies. A couple of quick points, and then I'll wrap up with some ideas of where we go then. This doesn't solve the ubiquity problem. Those pressures will still exist. But keep this in mind. The ubiquity problem is a genuine one, particularly in a globalized world, but it costs far more for a firm to pick up operations and move them over a border than for a firm simply to choose to charter somewhere else. It is almost free for most firms to charter in Delaware because the costs of changing physical spaces exceed the cost of chartering. This will make it more difficult for corporations to opt out of local governance requirements. So that's the first point. The second point is that over time the idea here is to shift the norms in terms of corporate governance. And that will make, for a number of reasons, physical exit simply for short-term gain will be a less attractive option. Second, some shareholder primacy advocates might be concerned that any state reform effort that allows managers to elevate other interests over those of shareholders would allow management to entrench themselves. And this was the criticism lodged against state anti-takeover regimes in the 1980s. That's a legitimate point. Although it's a point that only applies to publicly traded firms, it does not apply to privately held firms who can also opt out by choosing Delaware. And importantly, it doesn't apply to the subsidiaries through which most publicly traded firms operate. So it's a concern, but it's a limited concern to publicly traded firms. The way to deal with that concern then is to give more direct shareholder access to corporate governance as a counterbalance. Interestingly enough, in the 2006 Act in the UK, where they revised their entire corporate code, they struck that balance. They struck that balance there, greater shareholder access. Okay, finally, is this proposed regime going to create all kinds of interjurisdictional conflicts that's going to make it hard for firms to operate? There's inefficiencies with trying to comply with different corporate governance regimes. I don't see the conflict arising with regard to many of the types of reform proposals I would suggest, but to the extent that kind of irreconcilable conflict emerges, the remedy is federalization, not a system where one state that is not politically accountable can govern governance every place else. So the remedy is federalization if that kind of conflict emerges, not a system where Delaware law is the only law that applies to corporate governance, and Delaware is not accountable to all of these other stakeholder groups. All right, so once we've made that doctrinal step, then the second question is, well, what kinds of mechanisms can we use, can we implement to have greater greater stakeholder a greater stakeholder role in the firm and change the norms within the firm so that stakeholder interests are considered to a greater extent. I would suggest that there are 4 categories of reforms. There's a 5th one which I won't talk about, but I'll mention it. Disclosure regimes, what I would call deputization regimes, process-oriented mandates, and then the fourth and final one is what Kent talked about, and that is direct representation types of approaches. So disclosure, deputization, process-oriented mandates, and representation. The fifth category, which I think is an important one, but it's sort of too vast an area to talk about, is direct regulation of corporate political activity, which obviously has spillover effects on other stakeholders, but there are a whole host of other issues that arise once you start to limit political activity, constitutional questions, and the like. I'm going to leave that one aside with the idea that if we change internal corporate structures, ultimately that would be less of a concern because the internal norms would be different. Real quickly, some ideas. Disclosure. You can utilize disclosure requirements to help stakeholders overcome informational disadvantages in bargaining, apply external pressures for change, perhaps market pressures, or seek legal reform. Well beyond the securities disclosures for publicly traded firms that we currently have, we could impose disclosure requirements on a vast array of subjects that would make firms more transparent and would give others the information they need to play a greater role in addressing what firms do. Forecasts regarding economic activity, audits regarding energy use, discussions about downstream strategies with regard to physical plant, anticipated personnel changes, and the like. We could even have a manager's MD&A with regard to some of these particular issues. This goes far beyond the kinds of disclosures we require currently in our federal securities regime, and they would also apply to private firms. And this would, again, provide important tools for other stakeholder groups in seeking to protect their own interests. Deputization. To enhance compliance with external legal mandates that protect other stakeholders, we could deputize various corporate actors, give them the authority and the incentives to monitor corporate activity and prevent or correct illegal or harmful conduct. We could expand the gatekeeper approach under Sarbanes-Oxley and have attorneys, auditors, and others play broader gatekeeping functions to address other issues besides complying with federal securities laws. In addition to that, we could deputize shareholders and allow them to prevent corporations from engaging in illegal conduct. This is in his book. Kent talks about bringing back the ultra-virus doctrine. This would be the way to do that. As I have argued in another article, we could also impose vicarious liability on high-ranking corporate officers for tort or tort-like statutory violations within the firm. This ensures that at least one natural person within the enterprise would internalize risks and monitor and prevent those risks and then spread remaining risks in a socially and economically optimal way. Process-oriented mandates. Works councils could be used like in Europe. One I want to mention real quickly, and I know I've gone a little over on time, is what happened in the UK Companies Act of 2006. So the UK is often considered to be the jurisdiction most like the United States when it comes to corporate law. Here's what the UK did 2 years ago. Their basic duty of directors, this is in terms of the duties that directors owe to the firm, are outlined in Section 172. It is the duty to promote the success of the company. A director of a company must act in a way he considers, in good faith, will be most likely to promote the success of the company for the benefit of its members. Members are shareholders. For the benefit of shareholders as a whole. And in doing so, have regard for, among other things, the consequences of the decision in the long term, the interests of the company's employees, the need to foster the company's business relationships with suppliers, customers, and others, the impact of the company's operations on the community and the environment, and the desirability of the company maintaining a reputation for high standards of business conduct. It maintains the shareholder wealth maximization norm in a sense, but it mandates, it doesn't just allow, it mandates consideration of these other interests and other stakeholders. And it's received a lot of attention, but the idea is to change the conversation. If you took that and combined it with disclosure, and then some kind of enforcement mechanism, that's a pretty powerful shift in what we currently require, would be a powerful shift in what we currently require of boards of directors. Finally, Kent's already talked about it, but you can move to a direct representation model where either employees, community representatives, or others could actually directly represent these other interests on the board. And then I think tied to that, to counterbalance, you would also have direct access to the board, more direct access to the board of shareholder groups. So I've gone over. I will stop there. My one other point, again, this is appreciating what you have done here at Case Western with regard to this symposium. The relationship between communities and corporations, as I've already mentioned, is fundamental. I would suggest that the relationship, though, in a sense, is reversed from what we normally think of. So we're talking here about corporations and their communities. I suggest, in a very real way, that corporations are ours. Communities own corporations. They are creatures of law. I don't want to delve into all the theory about what ownership means, but in a very real sense, corporations are ours. So we have both the ability and the obligation to ensure that what they are doing, in fact, are benefiting our communities. And with that, I'll stop. Thank you.
Good afternoon. We're supposed to finish here by 1 o'clock. I'll try to meet that. I agree with much that Tim and Kent have said. I agree that Delaware law is not optimal. I agree that the interests of stakeholders should be considered in corporate governance. I agree that employees have an interest in the residual success, or in a general sense, profit of their company, even when they don't own stock in it. I believe that in the last 25 years, too much of our economic gains have gone to the wealthiest Americans, and that the resultant growth of economic inequality that Kent illustrated is undesirable. And in particular, the levels of CEO compensation now are obscene and economically unwarranted. And many companies have CEO autocracy that is inefficient and sometimes leads to disaster and scandal. I also disagree with them on many points, which I will discuss, but as a general matter, I would say that I don't think any desirable means of direct stakeholder participation in corporate governance have been identified. And I believe that the current problem with corporate governance is not shareholder primacy, but the lack of shareholder primacy, and that the institution of shareholder primacy would be desirable. First, a couple of comments about Tim's presentation. I wasn't entirely clear, maybe I didn't catch it, but I gather that his intent is that a corporation, the internal, what we generally refer to now as the internal affairs of a corporation, would be governed by only one state, and that would be the state with the primary contacts with the corporation. Is that right, Tim? You weren't clear on that.
Right, I was
okay.
I had plenty of detail to make it clear, but I ran over anyway. But
okay.
No, the answer is no, but in most circumstances it would turn out to be yes. But anyways,
okay, well, I'm not clear what that would be, but at the least we would, I mean, what state would control General Electric's internal affairs? Presumably it's not going to be 37 different states all dictating different rules for the board of directors. It's going to have to be one state, and I would assume it would be the one with the primary contacts, which first of all might raise interesting questions. That would be also have to be a matter of federal law, so that different states couldn't use different criteria as to, well, where are the shareholders located? Well, we don't use that. We look at where the assets are located. There would have to be federal rules about to say which state could govern, and that could certainly raise some difficulties anyway. I'd also be concerned about the interstate commerce constitutional issues that would arise. Suppose Ohio has jurisdiction over a corporation that decides that we're going to build, our old plant is obsolete, we're going to build a new plant in Arizona. And Ohio says, well, you can't do that. We want you to build it here. Well, the whole idea of having an interstate, a national economy is that a state cannot prevent that kind of thing. So we certainly have to have very strict constitutional limitations on the power of the state, kinds of things that in theory we could already run into, but in practice that we don't, because states can pick where to incorporate. Lastly, though, I'm not too terribly worried about it. I think it's not a good idea, but I'm not too terribly worried about it, because I think that as a result of the Interstate Commerce Clause, the ability of states to abuse corporations would be quite limited. That is to say, if they imposed regulations on corporations that rendered them inefficient, they would do what they do now, which is go somewhere else. More general comments, and talking more about Kent's presentation, although to some extent both. It isn't surprising, I guess, that kind of starting from square one, it isn't surprising that most people instinctively dislike capitalism. Who of us relishes competition from others? And the central phenomenon of capitalism, made famous by Adam Smith, the pursuit of private gain through competition with and exploitation of others results in public benefit, is completely counterintuitive. And so are many of its corollaries. For example, it seems logical that industrial policy should strive directly to maximize the quantity and quality of employment, yet we know from experience that this is self-defeating. To an enterprise, an employee is a cost. Costs are to be endured only when they produce greater gains, and costs are to be reduced or eliminated whenever possible in order to increase gain. Thus, government policy that aims directly to protect jobs are likely to impair efficiency, because again, the employee is a cost. You want to lower it or get rid of it if you can, and if government says, no, we're protecting those jobs, that's going to be impairing efficiency. And in fact, we see that job creation has been much better in economies that make it easier for employees to dismiss employees, for employers to dismiss employees either for poor performance or because innovation has rendered the employee superfluous. That's why we find that job creation has been better in America than in Western Europe, and we find that stagnant economies in Western Europe and France, for example, they are trying to reduce the government burden in order to encourage job creation. Given that the benefits of capitalism are counterintuitive, it's also not surprising that capitalism is never secure in a democracy. Everyone wants to be insulated from some effects of the market, and people do not readily appreciate its overall benefits. I like capitalism except when it damages me, right? That's the way we all feel, right? Kent has touted a desire for stability. But capitalism, as Schumpeter said, is creative destruction. Efforts for stability can easily produce stagnation. Specifically, Kent proposes some mechanism for non-shareholders to elect their own representatives to company boards. He says the details for implementing this proposal in one of his publications will be challenging but not impossible. Challenging, when I read, I said, now there's an understatement. Apart from its employees, what are the constituencies of General Electric that would be entitled to representation on its board, and how would they be chosen? Kent mentioned consumers. How are they going to vote on board representation? Communities in which a company does its business. Again, by the way, what is the community that would have to be entitled to appoint a director to General Electric? Obviously, there would be disagreement about that. And in any case, once we identify the appropriate community, how is it to be done? If it's in Cleveland, does that mean that the mayor gets to appoint 1 or 2 members of the board of directors? I can't think of any other way it could be done, and yet it seems to me that's not a very good way to proceed. This is not a minor quibble. Appointment of directors for political rather than economic reasons could cause serious damage, even if the political appointees were only a minority of the board. They would at least obstruct the efficient operation of boards and would appropriately be treated as spies and enemies by investors' representatives on the board. What you would have basically is the investor representatives would simply meet separately, decide how they're going to proceed, and then walk into the room and say, okay, here's the resolution, seconded, and let the minority members of the board spout off, and then, okay, now we'll call the question, and it would either pass or it would not pass. It would not produce a very productive boards. And in fact, there have been lots of cases where governments did appoint directors, and it generally has not worked out very well. By the way, would non-public companies be exempt from this? If so, that's a huge incentive to not be public, which we already see companies going private. Well, if the mayor of Cleveland is going to start appointing the board of directors for public companies, it's a pretty strong incentive to go private. Apart from the details of implementation, stakeholder governance is dubious in principle. The interest of shareholders is to maximize the present value of all the company's future profit, and I think that that's a pretty good proxy for efficiency. No other constituency has anything like that perspective. Most employees don't care about their companies beyond their own tenure, and the median time Americans stay in a job is low and dropping. Nonetheless, I hesitate to reject the idea categorically. I never like to say this is impossible. I only like to say things, under the current circumstances, things are impossible. We can't make a perpetual motion machine. Maybe someday somebody will, but right now we can't. It hasn't happened yet. Like many stakeholder theorists, Kent says stakeholder governance has the potential to grow the pie. And when I see that, I say, wait a second, if that's true, why hasn't it happened already? If stakeholder governance can produce a bigger pie, then it should be able to produce a bigger piece for each constituency. I realize that in some cases, pie-maximizing solutions can't be reached privately because the transaction costs of negotiation are too high, but at least for employees with collective bargaining, that shouldn't be so. They're negotiating with management already. My students know that one of my favorite illusions is the Sherlock Holmes story of Silver Blaze. That's the story that Holmes solves in part by noticing the dog that did not bark. It showed that the culprit was an insider, because if it had been an outsider, the dog would have barked. And it's interesting in this case to note the dogs that are not barking. Kent touts his proposal as beneficial to employees. Well, if he were right, we should see groups of employees, first of all, forming firms and hiring capital. If it's efficient, why don't the employees get together and say, why wait for shareholders to form a corporation and hire us? Why don't we form a corporation and hire capital? Well, actually, we do see this, but not at all in the way that stakeholder advocates want. In fact, most companies are controlled by employees, but only by a small elite group of employees. Law firms are run by their partners. When outside equity capital is needed, venture capitalists provide it, but only on conditions that are not at all what stakeholder theorists envision. So yes, we do see it, but not at all the way Kent envisions. And American organized labor has shown very little interest in board representation. And here the exception proves the rule. In the Chrysler bailout some years ago, one of the conditions was that Doug Fraser, head of the UAW, be appointed to the board. But as soon as Chrysler returned to solvency, Fraser quit. He obviously felt that it was not beneficial to employees for even his one seat, to have even his one seat on the board, and this is simply not an issue you see American unions raising. And in fact, in Europe, Kent mentioned co-determination, but the power of labor representatives tends to be pretty small. There are two boards, and the one that really makes all the decisions doesn't have labor employees. And there is indeed some trend to phase out co-determination. So I think it's highly dubious that we can say, oh, look how well it's working over there. We ought to imitate them. Kent says no constituency would have an incentive to hurt the company in order to gain a larger slice of the pie. Well, I'm not sure what he means by hurt the company, because after all, the company itself is a fictitious person. But why wouldn't the stakeholders just decide that there will not be any payouts for shareholders? Ever. Even if that might eventually injure stakeholders, the damage might not occur for a long time after the current mayor of the town who appointed the community representatives and after the current employees are gone. You know, I'm 60 years old. If I'm going to retire in 5 years, what do I care that the company's going to run out of money in 6 years? I don't believe that markets are perfect, and in light of the current subprime mortgage crisis, it's hard for me to see how anyone can. We don't have any of those people here, but believe me, there are in academia some people who do seem to be market perfectionists. But to admit that markets are flawed does not mean that we must accept what has been called the nirvana fallacy, that is, that government regulation is necessarily the solution. In particular, the more government gets involved in the details of anything, the more likely the results will be bad. For similar reasons, I'm skeptical about federalizing corporate law. I agree with Tim and Kent that there is no race to the top among the states to provide the best corporate law, and that Delaware does not dominate because its law is most conducive to economic efficiency. I have lots of problems with Delaware law, but it doesn't follow that federalization would make things better. Look at the economic role of Congress now. It routinely makes decisions based on the political interests of congressmen, wasteful home district pork projects to attract votes, and favors to wealthy interests to attract campaign contributions. By the way, in terms of economic regulation, here again, one exception proves the rule. One of the successes of economic regulation, I would argue, at the federal level, is with respect to the Federal Reserve, in which what did Congress do? It tied its own hands and said, we won't interfere with it. That's the way for Congress to regulate the economy. Nonetheless, I admit the federalization of the securities laws, though flawed in many ways, has on the whole been beneficial, and later I will suggest a step that I think would be great as a federal corporate law. Again, I'm not a free market purist, but I think we should be skeptical and entertain a pretty strong presumption against government intervention. Proponents of regulation should bear a heavy burden of proof. With respect to corporate governance, the proponents of regulation simply have not come close to satisfying that burden. I want to preface what I'm now going to say by making it clear. I'm not accusing Tim and Kent of being un-American.
I've been called worse.
But getting serious now, I want to persuade you and them that this isn't just an issue of distribution among domestic interest groups, but is rather a matter of national well-being. After World War II, the U.S. was unique as a safe place for capital investment. Its dominance has shrunk a bit with economic growth of Europe and Japan and so forth, but until recently its status was secure. That is now ceasing to be true. Capital in international, capital is international and fluid, like quicksilver. China, India, Brazil, and other countries have adopted capitalist ways and become more attractive to investors. One recent study using measures developed by the World Bank found the U.S. to be below average in investor protection. Now, that's by the way, a response to Kent's complaint about shareholder primacy. U.S. is now below average in shareholder protection. If investors in American public companies continue to suffer the abuse and contempt of CEOs that is now common, they will go elsewhere. To some extent, they already have. The proliferation of private equity stems in large part from the benefits of avoiding the agency costs of the separation of ownership and control characteristic of public companies. But private equity is not a complete solution to the problem. It is not a practical solution for all investors. It is not practical for all companies. So what will investors do? They will go abroad. To some extent, they are already doing so. And foreign investors, more and more, are staying away rather than coming here. If this continues, American firms will have to pay more for capital than foreign competitors, and our economy will suffer. And workers and communities will suffer most. Investors won't suffer so much. They'll go abroad. It will be the workers and communities here. You can't take Cleveland abroad, right? These are the workers and the communities are going to suffer most. And if progressives care about them, this is the problem on which they should focus. There are many proposals to strengthen shareholder protection. Many of them would be beneficial but trivial. That includes proposals tabled recently by the SEC to allow shareholder nominees for the board. Good idea, but trivial. I have proposed what I think would produce real change. A corporation's slate of board nominees on its proxy statement should not be chosen, as is now the case, by the incumbent board, which is usually dominated by the CEO, which is to say new directors are CEO's buddies, or at least people the CEO trusts not to rock the boat. Rather, they should be chosen by a committee of the 10 to 20 largest shareholders. That would ensure the selection of directors who are truly committed to maximizing share value. And that, again, I submit, should be the goal for progressives. First, employees tend to be paid better, have better job security, and better opportunity for promotion in firms that are profitable and growing than in firms that are stagnant or declining. More important, workers generally fare better in a growing economy. Kent charges that investors are obsessed with the short term. Now, that is a common claim expressed and maybe even believed by many CEOs, as Kent indicated, but it's a myth. Some investors, perhaps many, are unduly focused on the short term, but for markets to be efficient, only a critical mass of rational investors are needed, and that clearly does exist. Firms that are really controlled by investors, like private equity and venture capital control firms, are not at all short-term oriented. To the extent that we now have a problem of short-termism, and I'm not sure it's a serious problem at all, but to the extent that there is such a problem, it is primarily a result of dominance by CEOs who in some cases try to deceive the market so they can pump up the company's stock price above the exercise price of their stock options and then dump their stock before the truth comes out. Outside investors can't do that. I realize that what I'm proposing is not a complete solution to the problems of workers, communities, the environment, etc. Those are serious problems. We need to do things about that. We should, for example, have programs to help workers and communities buffeted by the creative destruction of capitalism. What precisely those steps should be, however, is the subject for another symposium. Thank you.
Thank you very much. I think even though it's nearly 1 o'clock, we might give both Tim and Kent a few moments to have a creative response.
No, the time's up.
And so if you want to take a few moments, that would be great.
Go ahead. Thanks, George, really for those very thoughtful responses and careful reading of my work in particular, which I really appreciate. Let me say a few words in collegial response. And I can't, there's no time to answer all of George's challenges, and I'm not sure I could in a complete way. But let me say a few things. First of all, I understand George in part to say that the more we should have a presumption against government intervention. The more government gets involved, the more likely a bad result will occur. Then at the same time, he says, well, we need more further legal and governmental protections for shareholders. The SEC needs to change rules for director voting and the like. And he even says, well, we do need more regulatory protections for employees and other stakeholders when they are buffeted by the creative destruction of capitalism. I completely agree. I might even endorse some of his shareholder protection options, but just note that these are government activities and government regulation. And I even think that corporate law is best seen as government protection. The duty of care, loyalty, and good faith is the operation of the government to step in to protect shareholders. I simply think that government has a role in protecting other stakeholders as well, and instead of having corporate law be only attuned to interest of shareholders, I think they should be attuned to interest of stakeholders as well. Now, one reason why George contests that view is that I think he says that it's more that a view of stakeholders within the fabric of the company would obstruct the efficient operation of the board. And it makes some sense because employees are cost, he says, and cost should be eliminated. But just note that from the standpoint of the firm, shareholders are costs too. They have costs. It costs money to raise capital. And another point in his remarks, he did talk about the cost of capital. So from the standpoint of the firm, the entity, it costs them money to raise capital, it costs them money to gather labor, it costs them money to gain supplies. And it's not ex ante clear why one stakeholder, the shareholders, ought to win and other stakeholders ought to lose within the corporate form. Now, he does make the point that shareholders are the better proxy for social wealth. Now, here I think it's just an empirical disagreement, and I do disagree in part because I think while I believe and I agree with George, when for the most part employees are better off when companies are growing, when the market is growing, and I am a capitalist as well, but I don't think necessarily that shareholders are the best proxy for social wealth for a few reasons. It's easy to transfer social wealth to shareholders and away from society. And there are numerous examples of this. Walmart, recent documents show, has assumed internally that the best way for them to provide health care is to pay their workers so little that they qualify for Medicaid and Medicare. So, and a recent congressional study shows that we subsidize Walmart from the public till about $2,000 per employee per year to provide for their health care expenses. So what Walmart does to maximize the value to shareholders is to transfer wealth from taxpayers, from society, to shareholders. And I do think because shareholders, the assumption goes, retain and buy up a diversified portfolio of securities, that they are really indifferent with regard to the failure rate of any individual company. But employees are not indifferent to the failure of their own companies, and so therefore employees may in fact be a better proxy for social wealth if we value some measure of stability or at least continued health of individual companies. Finally, to answer why don't companies do this already if it would be growing the pie to do it. And I think there's a couple of answers to that. One is that it doesn't occur to people. Secondly, for the same reason Microsoft didn't develop the iPod. It just doesn't occur to them, right? And it takes innovation by some companies to create wealth. And I think there's a first mover disadvantage, or in other words, there's a collective action problem. Companies might want to do this if they can find a way to do it and guarantee that other companies do it as well. So I do think that we would, if we required it by law, that stakeholders are more taken into account, we would see that it would grow the pie over time. In other words, there are defects in the market that prohibit or prevent companies from doing that. So let me stop there and just, again, thank George for his very challenging comments.
Yeah, I wanted to say thank you as well. I hope the conversation continues because there's a lot to discuss. Kent covered a bunch of what I was going to say, so I'll keep my comments very short. Two things to emphasize again in terms of what Kent says. One, firms can increase value or returns to shareholders by externalizing costs on society. Happens all the time in various contexts. So, unless we recalibrate how we determine what an appropriate return is, or how we go about regulating how firms engage in decision-making about what constitutes growth within the firm, we are not going to solve that problem. Externalization can equal greater shareholder return, and that continues to be a problem that I think is unaddressed in the current context. That was worth emphasizing. Secondly, a very related notion, it is not necessarily the case that growing the size or the overall success of the company means greater returns for shareholders. Flipping that around, really, what I'm suggesting is it isn't necessarily the case that you have to increase overall success of the firm if you can. In other words, you don't have to increase the overall success of the firm necessarily to increase the return to shareholders, and therefore the two don't necessarily go together. Why the market hasn't produced this is an interesting question. Again, I would think, and I can't get into details on this, but it isn't just because the market is ultimately structured efficiently as long as we take some of the steps that were suggested to protect shareholders. It's also because of capture of our regulatory institutions, other types of capture, but also capture in the markets in terms of how we perceive success. A couple other quick points. Again, capitalism to me is not in dispute here. The question is, how do we utilize capitalism in a way that is more productive for society as a whole. And I also, it's interesting because just to emphasize my Americanness, I too doubt that Congress always gets it right. What I would suggest is that in thinking about capitalism and thinking about who ought to regulate, I think the first step in that process is that we have to consider who ought to be involved in making democratic decisions. And the situation we have now is the worst of all possible worlds, where we have a jurisdiction which governs a huge portion of, has enormous influence on the most important economic actors in our society, and it is not democratically accountable to any of these other stakeholders. So although I agree that Congress does not always get it right, and I'm skeptical that at the federal level things will be perfect, of course they won't be perfect, but that is certainly a more appropriate forum for making these kinds of decisions than the current structure. Final point on interjurisdictional conflict and the idea that who is going to govern GE under my scheme? Couple of points. That concern is certainly most appropriate where you have firms with substantial operations across state lines and stakeholders across state lines and multiple sovereigns addressing the firm. But we live in a society where that is the regulatory environment in other contexts as well. I mean, if we think that corporate governance is an appropriate area for further regulation, to me it seems like there's no difference between that and having multiple jurisdictions govern in other ways. One jurisdiction may impose certain duties not to trespass on land. Other jurisdictions may impose a different kind of duty in that context, and where you have one economic actor that may engage in that conduct in two different jurisdictions, there's going to be a conflict. Is it necessarily irreconcilable? No. Where it is irreconcilable, we have a couple of possibilities. One, I would agree with George that there are interstate commerce implications on the margins, and there are also full faith and credit implications on the margins for those states that would seek to extend their regulatory authority too far. I don't think that's as much of a problem as has been suggested, because I think, again, many of the things I propose could occur, would not create irreconcilable conflicts. I also tend to think in our federal system that those kind of conflicts get worked out over time. But the bottom line is that if we have that situation and we have certain firms that cannot be regulated more locally, then the remedy is federalization, not the current situation. One other point is that much of our discussion has been focused on publicly traded firms. And I think one of the dangers of any discussion like this is that we assume that the principles we're talking about would apply to all other entities. And all of us have touched on private equity and the like. But keep in mind, a huge amount of the business activity that occurs at the local level in this country is through privately held enterprises, either non-publicly traded firms or subsidiaries of non-publicly traded firms. Local control of those private enterprises is something that we don't, and the governance of those enterprises is something that we don't focus on enough. Fears about the capital markets and the effect on the capital markets only apply to one set of firms. It does not apply to all of these other firms that are privately owned. So oftentimes I think the discussion of corporate law gets too tied up in too focused on public entities without considering that, in fact, the nature of corporations, of business entities in this country is far more diverse than that. I will stop.
I guess we're going to continue and take a few more minutes before we all get to satisfy our hunger pangs. Any questions from the audience?
We're below average in shareholder protection or investor protection. Who's above average?
Oh, some of the Western European countries, UK especially, I think was ranked much higher. Richard, you might know, wasn't it? Yeah, UK definitely. UK definitely.
Yeah, absolutely. And I would add to that, and the 2006 Act in the UK puts an enormous amount of shareholder protection, a new protection in the UK that didn't exist previously. What's interesting about that, though, is that while it is also much more protective of shareholders, we disagree a little bit on the facts on the ground, I think. Actually, the European countries, rather than moving away from a conception of the firm which includes employees in governance, are in fact attempting to make that a permanent feature of the EU. Although there is pressure on co-determination in Germany in terms of work councils and their ability to make firm decisions, that's not going away anytime soon. And in fact, the UK now, under certain EU directives, is going to have to consider what it may do along those lines. So it's both more protective of shareholders in Europe and more protective of workers.
I'm not an expert in corporate governance at all, despite being a participant in this conference for my alleged expertise in other areas. But if there is this dispute about, is co-determination better in some other form of organization, or is there sufficient protection for shareholders? Why not consider the alternative of simply deregulating corporate governance entirely, and then firms with different types of organization can compete to attract workers, to attract capital, and so on. So if the current structure doesn't provide enough protection for shareholders, other structures might emerge where shareholders are willing to invest. And similarly, if workers are better off with co-determination, which I doubt, but maybe it's true, then companies that have co-determination would enjoy advantages in attracting capable workers, and therefore would enjoy a competitive edge in that respect. And then we could see if it really is the case that co-determination is better, then companies with co-determination will tend to displace others, and similarly those with tighter controls on management might displace those where management is more free, if indeed currently we have a problem with CEOs exploiting the shareholders for their own benefit. So I guess that's my question. Why not that option? Or maybe if you do agree with me, then that's fine also.
Well, I'll just say briefly, that's what we have now. There's no law against having employee representatives on the board. Firms just don't do it. And now Ken said something about, well, it's not, it hasn't been done, and innovation and so forth. Innovation is what the American economy is all about. If there's an idea that will make money, somebody is going to do it. So when you see that something is not happening, I think it's a pretty strong indication it's because people don't think it's a way to make money.
Would you say the same thing about the shareholder protections that you've I mean, it seems like if the free market is going to, if money is to be made by somebody, that would also apply to your point about.
Well, I would say in response to that, first of all, we are seeing reactions to it, and it's not proceeding directly to the point I think we would like to get to, but we do see people fleeing public companies by taking companies private, so you're not abused by CEO dominance. We see investors taking their money abroad. We see venture capital, again, where you've got investors really have a voice. And we see more assertion by institutional investors now against things like poison pills and staggered boards that are very damaging to investor interests. Now, I'm not a free market purist. This doesn't happen with lightning speed, but we're moving in that direction.
We have time for one more question.
Thank you, everybody.
Thanks a lot. I guess we should give a round of applause to our panelists again for a great presentation.